Okay, so I'm just briefly going to go through two common problems that come up in terms of written contracts. The first one is something that I get asked quite regularly by HR employers. Is this person an independent contractor or are they an employee? It's quite a technical area again, but it's something that really is objectively measured. There's been quite a bit of case law on it, and employers need to be aware of the risks, both in terms of employment law, sham contracting under the Fair Work Act, but also under tax law, that they could be liable for penalties and payments. The crucial question that needs to be asked in determining whether someone is an independent contractor from an employment law perspective is how much control is exercised over that person. So some of the things that can be considered in that sense are hours worked. Is the person determining themselves the hours worked, or is the company? Are they determining when they have breaks, or is the company? Are they determining when they can go on leave, or is the company? Are they wearing a uniform? Because that's come up in quite a lot of cases. What are their duties? Are they unique duties that we don't have anyone else within the company that is an employee carrying out? And one other issue can be equipment. So are they working on their own computer, using their own IT, their own car? Things like that can come into play as well.
Sorry.
Yeah.
And I mean, it's a really complex issue, and we don't have time to go into too much detail, but one thing I'll say, anyone that contemplates an independent contract arrangement, the key is to make sure by practical measures that your contractor is complying with super, tax, workers' comp, etc. Now, if while making them comply with that, they suddenly lose interest in being a contractor, that tells you something.
Absolutely, and I think obviously the word independent is crucial here, and I think sometimes employers forget that and think about what's sort of convenient for them. In terms of the sham contracting provisions, even if you're reckless about are they really an employer or a contractor, you can still be liable for penalties. And that's both the company and directors personally. So one clear example of this type of consideration is a High Court case. It was actually a vicarious liability case. A courier hit someone over in the street and they injured that person. The person saw on their uniform that they had the name of this particular courier company, and they sued them for personal injury. So it's not an employment law case, but the High Court then had to look at, well, is it actually their responsibility, or is this person an independent contractor and they individually should be sued? So what they looked at in this particular case was the fact that these couriers had to turn up to work at a certain time. They were wearing a uniform. Yes, they provided their own equipment, a bike, but they could also use that bike in their personal time as well. They couldn't negotiate how much they were paid. It was a set amount and there was no variation between couriers, and they couldn't take leave when they wanted to. They had to apply for leave and get it approved just like an ordinary employee would. So in this particular case, I think it's just a really good example of a role where an employer said, well, we're going to have all independent contractors because that's convenient for us. We don't have to deal with a lot of the admin side, but in fact, they were employees. All right, now the second common problem that I wanted to look at is outdated contracts. And this is something that I'm sure a lot of you, whether you've moved into a new company or you're doing a revision of contracts, have thought about. This particular case is an example where it almost went wrong for Qantas, but on appeal they were sort of redeemed. So I'll just talk you briefly through that, and then I've got a bit of a checklist in terms of when you should actually update your contracts. Two women that actually applied for a secondment, full-time secondment role, but wanted to job share the role, and Qantas agreed to this and said, yes, that's fine. They then turned around and said, oh, but actually can we make it permanent? And Qantas said, no, we want to have sort of fixed term 4.5 years. They issued some written documents that the employees never signed. And then at the end of the 4.5 years, Qantas turned around and said, would you like to apply again for a further period? And they both said, oh, but we thought we were permanent. There was nothing in writing that had been signed. They took it to court. At first instance, they were successful, and then Qantas appealed, as it often does, and it was found to be successful. So they weren't in fact entitled to that role as a permanent role. But obviously you don't want to end up in a position where you're having to go to court and then appeal it to sort of show that in fact this situation is a fixed term situation, it's not permanent. And a case where this often applies is where you have flexible workplace requests. So someone might be coming back from maternity leave, they were working full time, they want to come in part time, or they want to do different hours, maybe different duties are offered. Things like this that often are verbally discussed and potentially not put in writing. A couple of years later when their children are ready to go to school, they might turn back around and say, okay, I'm ready to resume my full-time duties. And the employer's sitting there thinking, well, I didn't think you ever wanted to go back to them. I've already got someone in the role. So it's really crucial that you do get these things written down, whether it's a fresh contract or a variation letter that refers to that particular contract.
And that's one of the key issues that we have seen in recent years is uncertainty about flexible work arrangements and how long they'll last.
Yes.
Where you've got the 2-day week, 3-day week situation that hurt the employer thinking it's short term, the employee thinking it's short term, complete uncertainty. So we now say always have review provisions in there and as to whether it continues and state whether the person is giving up their full-time role. Because say, for example, if someone's coming back after a baby, if the husband's made redundant, there's so many things, and then they just want to come back, and they can't because of the job share partner. It's one of those, it's an absolutely vexed issue at the moment.
So this is just a list of where you should be looking at updating contracts, either a fresh contract or a variation that's documented and signed. Obviously new employees, you're going to have a fresh contract, but you want to make sure when you're giving them out to sign that they are up to date, that they include the things that we've talked about and don't include the things that we've said you shouldn't include. Where there's insufficient protection or it's generally out of date, you want to make sure that if they move into sales, potentially they have a restraint clause, so you're going to need to update it. That ties in with the next one, change of role. If someone's become more senior, if there's going to be differences in their terms and conditions as a result of that, you may just need to do a variation letter referring to the new terms and conditions and that everything else still applies in the contract, but you want to make sure you're looking at it. Also, where you have terms varied by a flexible work request, or where they're varied by the employer on notice, you want to get that all down in writing so that you have documentation to go back over if it's ever called into question.